Hi, my name is Kyusung Lee, head attorney of Osung Partners Law Firm. Recently, there have been numerous labor issues rising in the startup sector where I specialize, and clients have been approaching our firm for assistance. One recurring issue, along with wrongful termination and false allegations by employees, is workplace harassment. Particularly, there have been frequent cases where employees who are involved in false accusations reporting them to the company claim that they have experienced workplace harassment in the past. In this video, I will provide specific information on workplace harassment as an extension of the topics discussed in previous videos. Workplace harassment refers to actions where a user or employee exploiting their position or relationship in the workplace goes beyond the appropriate scope of work and inflicts physical or mental pain on other employees or worsens the working environment. The regulations related to workplace harassment can be found in Article 76-2 of the Labor Standards Act. To establish workplace harassment case, a comprehensive assessment is required, taking into account factors such as the relationship between the parties, the location of the incident, the situation, and the persistence of the behavior. It must be recognized that actions have resulted in physical or mental pain to the victim or deterioration of the working environment. The specific items that must be met to determine the occurrence of workplace harassment as specified by our laws are as follows. First, exploiting a superior position or relationship in the workplace. In general, when an individual holds a higher position or ranks higher in the chain of command within the workplace, their superior position is acknowledged. Additionally, superiority can also be recognized in relational aspects. Various factors can be considered in determining superiority, such as whether it is an individual versus a group, regular employees or non-regular employees, educational background, age, place of origin, race, length of service, and influence within the workplace. If, upon considering these factors, the superiority of the position or relationship is not recognized, workplace harassment cannot be established. Second, actions exceeding the reasonable scope of work. If there are unwarranted actions, instructions, commands, or verbal abuse in situations where the necessity for work is not acknowledged, it is generally considered to exceed the reasonable scope of work. The necessity for work can be broadly recognized based on comprehensive work-related relevance. However, if the actions towards the victimized employee are conducted without reasonable justification compared to similar employees in the workplace, it can be socially perceived as exceeding the reasonable scope of work. Additionally, the determination of the necessity for work may also be based on the provisions specified in the employment contract, collective agreements, employment rules, and relevant laws. When dealing with workplace harassment issues, it is necessary to review such documents as well. Third, infliction of physical or mental pain or deterioration of the working environment. Determining what constitutes deterioration of the working environment can be a vague concept. Generally, if the actions of harassment prevent the victim from being able to perform their duties to an extent where their abilities are impaired, it can be considered as a deterioration of the working environment. For example, if a user repeatedly assigns difficult tasks that are not specified in the employment contract only to a specific employee, or consistently assigns menial tasks, or barely assigns any work without valid reasons, or repeatedly excludes the employee from work without justifiable cause, it may fall under the category of workplace harassment. Regarding workplace harassment, there is a provision in the Labor Standards Act that stipulates the employer's obligation to investigate. This is very important. When workplace harassment occurs, anyone who becomes aware of the fact can report to the employer. According to Article 76-3, Paragraph 2 of the Labor Standards Act, upon receiving such a report, or becoming aware of the fact of workplace harassment, the employer must promptly conduct an objective investigation targeting the parties involved to verify the facts. Failure by the employer to fulfill this investigation obligation may result in a fine up to 5 million won. Furthermore, the employer is required to take various measures specified by the laws, such as prohibiting unfavorable treatment or retaliation against the reporting employee and the victimized employee, implementing appropriate measures for their protection, and taking disciplinary actions against the perpetrator in such cases. Handling workplace harassment issue is considered to be a particularly complex and challenging matter among labor issues, and many clients approach our law firm expressing their difficulties. If you are struggling with workplace harassment issues, we encourage you to seek assistance from our team of specialized attorneys at Osung Partners. We are here to provide our expertise and support in addressing and resolving workplace harassment problems. Thank you for watching.